All right. Cool, Nick. So, especially in the South African landscape and framework, we do experience a lot of questions when it comes to property leasing and a situation where there's wild animals present on property and they move from one property to the other. And then there's domestic animals and possible injury to the wild animals or other sort of farming animals, the breeding issues. So maybe speak a little bit about that. We have the question particularly here is around a domesticated animal, a dog, that escaped one property, went into the other property, the landlord's property, and managed to kill a buck in the process. And the landlord obviously now being aggrieved, wanting to cancel the lease agreement. So maybe just take us through the laws relating to that.
Okay, perfect. So just to start out, I want to do a little distinction on animals within South Africa because it's important for our context. So in South African law, we distinguish between two different types of animals. There are domesticated animals. These are your normal dogs, cats, things that you would ordinarily have around a household. And then there are wild animals, which are wilder animals, things you don't keep around the house, buck, etc. And the way that these animals are treated in our law differs. Okay, when you have a domesticated animal, you as an owner of a domesticated animal are responsible for the conduct of your domesticated animal. It's your responsibility as the owner to ensure that your domesticated animals don't damage other people's property. Okay, and when your animal moves around, you still retain ownership of that particular animal. So if your dog runs off and it goes onto someone else's property, it's still your dog and you're still responsible for the conduct that it has when it's on someone else's land. Okay. It's slightly different when it comes to wild animals. Okay. And the ownership of that animal doesn't necessarily attach to the person who owns it. The ownership of that animal exceeds to the land, and there's responsibility for damages that those animals might cause is not necessarily just put onto the owner. There are other questions like negligence, etc., on what you were doing, but those animals are treated as wild. So the conduct is not necessarily imputed onto the owner of those particular animals just by virtue of the ownership. Okay, so this is the distinction we have. And in this particular question, we've got a tenant whose dog has run onto the landlord's property and has killed a buck in the circumstances. So as I've already pointed out, as the tenant, you are responsible for the conduct of your dog. Even if it moves onto the landlord's farm, it's your responsibility to make sure that your dog doesn't cause damages in the circumstances. So in this question, we've been asked, the landlord wants to go ahead and cancel the lease agreement. And we've been told that the lease agreement does not allow for dogs to be on the particular lease premises. So in this question, what's interesting is even though there's been this incident where the dog has killed the buck, the ability for the landlord to cancel in the circumstances actually won't be contingent on that particular incident having happened. The lease agreement itself says that there's no ability to have dogs on the particular premises, and so the fact that the tenant has a dog on the premises is simply a breach of the lease agreement, like any other breach in the circumstances. So for the landlord to cancel the lease agreement, they are simply going to give a breach notice as any other breach in terms of the lease agreement. You're going to follow the provisions of the lease agreement on what the time period is. So 7 days if that's required by the lease agreement. Please remember, if the Consumer Protection Act applies to that particular agreement, I don't have the facts on that, but if the Consumer Protection Act does apply, then you will have to follow the provisions of the Consumer Protection Act, give 20 business days notice, and then simply cancel if the breach is not remedied. So in this circumstance, you are demanding that they remove the dog in the circumstances. I understand that is harsh. We do have a lot of clients who come in, where they've been demanded to remove dogs or whatever the case is, and it is a touchy issue. But unfortunately, in circumstances where the lease agreement doesn't allow for dogs to occupy the premises, those provisions have to be followed by the tenants in the circumstances. So simple breach notice, cancellation in the event that the remedy that the breach is not remedied.
There we go. Awesome. Thanks so much, Nick. And yeah, to all our viewers, well, I think this video is going to be cut, so I'm going to say this anyway, though. But to all our viewers, Merry Christmas and see you next year.